Yesterday's lower Louisiana State Court ruling against the elected House's petition to pause the governor's extraordinary COVID-19 powers was disappointing. The House, working within the law, was merely seeking a seat at the table to have input in the governor's response to COVID-19. This pandemic has impacted our economy, the jobs and livelihoods of our residents, and the health and safety of our families. Our state government, like the federal government, has been successful because it consists of a series of checks and balances. No one person, no part of government is completely in charge. We have an elected legislature, an elected governor, and an elected judiciary. The goal is for each of these branches to work separately but together to serve the public. Our Constitution allows the legislature to pass laws, the governor to sign them, and the judiciary to uphold them while ensuring that the rules are followed. It should be noted that both the State House of Representatives and the State Senate created the Emergency Powers Law, and it was signed into law by a Louisiana governor. They chose to establish the procedure for the legislature to provide a check and balance on gubernatorial authority to the use of extraordinary powers. It's in the law, and it's simple to read. This law is no less obscure or unique than any other law on the books. The elected members of the Louisiana House of Representatives followed the law. However, the judge, hearing the case on the House petition yesterday, punted on enforcing the legal petition and then went beyond the law in giving the executive a rule by fiat power within our state government. This is concerning in a democracy. Should this ruling stand regardless of the emergency, a governor could simply start laying out edicts and renew them time and time again without any recourse from the public or their elected representatives in the House or Senate. This is why the House and the Senate, and even the previous governor, put the provision in place to ensure that those powers had a check. The judge, prior to this hearing, had a history of respecting the law. Unfortunately, yesterday, he ignored the law, and he used the Code of Civil Procedure to gain his desired outcome, while ignoring the rules if they failed to suit his purpose. He sidestepped regular procedure to herd the case to the outcome of his choosing, not the outcome which was set in place by the elected members of both the House and Senate, as well as a previous governor, when they created the law. Sadly, he did so by repeatedly showing disdain for the female attorneys in the Louisiana Department of Justice, while giving greater deference to the men representing the governor. He also bemoaned the public for viewing his courtroom, while the state limited the number of people who could watch because the proceedings were not recorded due to it being forbidden. We're only left to only the recollections of the few permitted to watch. Their testaments are concerned, and others from credentialed members of the media, should worry the court over the conduct of this proceeding. If the court wants to continue their approach to being beyond reproach and shaded from public scrutiny, they must stay within their lane of calling balls and strikes. They must rule on the text of the law and not write the law, because to do so places them in public scrutiny. If the courts continue their mission creep to engage in writing law, they should recognize that they will be open to the vast public criticism that those in the legislative branch of government must face. This is not the government the founders envisioned, and certainly not what the people of Louisiana deserve.